What do you think that this SEBI order means for its jurisdiction vis-a-vis the auditors of listed companies? What could be the potential consequences of the conclusion that unless SEBI can prove connivance or fabrication of books of accounts, mere negligence won't amount to fraud?
So again, it depends. I think what we have here is some kind of a fragmented regulation of the audit industry. So on the one hand, there is the Chartered Accountants Institute, which has jurisdiction over the accountants. Then in some cases, the Ministry of Corporate Affairs under the Companies Act also has certain oversight. And in this particular case, the question narrowly is whether SEBI has the jurisdiction. Now, basically, the issue is investors in the stock market rely upon the accuracy of the financial statements while they make decisions to invest. And the limited question before SEBI and SAT here is whether SEBI has the power to pass certain orders, because the conduct of the auditor has an implication on investor protection and the protection of the stock market as a whole. And here, it seems to be that SAT is now telling us that it is only when fraud can be positively and extensively proved that the jurisdiction of SEBI to pass preventive orders arises. But if it's mere negligence or maybe even gross negligence is insufficient on its own. So I think it kind of makes a distinction in terms of negligence or gross negligence on the one hand and fraud on the other hand. And in my mind, it actually lowers the standard a little bit for auditors in terms of the role that they play as far as the stock market is concerned, because SEBI can have jurisdiction only if they are able to discharge that particular conduct of being able to prove fraud. So SEBI's burden is very high in what SAT has told us, and conversely, the accountants or auditors' role or standard is slightly lower in terms of what we have been traditionally looking at from the securities market perspective.